My name is Frank Iacobucci. I'm an ex-law professor, an ex-deputy minister of justice, an ex-chief justice of the federal court, and an ex-justice of the Supreme Court of Canada. The charter is a moving picture. It's not appropriate to take a photo of the charter because, like law is organic. It evolves. It's evolutionary. And sometimes the evolution is quick, sometimes it's slow. But and the charter is particularly that way, and should be that way, because when you're interpreting the charter, you're interpreting the Constitution. And we know that constitutions, unlike statutes, are very difficult to amend. And the charter interpretation that is issued by a court, and in the Supreme Court, is in place until it's either amended or overruled by or modified by a subsequent decision if there's no amendment of the Constitution. So the stakes are pretty high in that exercise of a charter interpretation. I believe that the record of the Canadian judiciary is an impressive record. This is highly personal, but I've been going to the Yale Law School for the last 15 years as an invitee of the Canadian judiciary when I first went, along with 15 other jurisdictions from around the world of constitutional democracies. The U.S. Supreme Court has had one or two judges there every year. The German Constitutional Court, which is a leading court in the world, has had representation. The Israeli Supreme Court, very, very impressive court, representation. Italians, European Court of Human Rights, and so on and so forth. And I have to say, in all honesty, the record of the Supreme Court of Canada and of the courts of our country is held in high esteem by those countries. Canada has been a major player, if I can say it, judicially speaking, in the global constitutionalism that has taken place over the last 25 years that includes the breakdown of the Soviet Union and the Eastern Bloc and so on. I'm saying that with a great sense of pride, but you know, the wide Canadian public doesn't know that. We don't, it's in our Canadian DNA not to brag, and I'm proud of that. I don't think we should change the DNA, but I do want to point out that it is something that has shown that, firstly, that the Canadian judiciary, people will disagree with this, but the Canadian judiciary, the men and women on the bench, lived up to the challenge that the charter was, because it was a completely different set of challenges, different from federalism, where you declared one government offside under the Constitution, 91, 92 federalism cases. This was much more challenging in that this was saying certain enactments or certain executive action no government could do, neither federal nor provincial. And that is a real tall order. And the real challenge, just to this day, it's not changed, and it's this. In the charter, it's going to be easy to say what I'm going to say, but difficult to be faithful to what I'm going to say. There is a difference between being a Supreme Court and a Supreme Legislature. So the challenge under the charter is to draw that line between interpreting the Constitution, the charter, in such a way is that you're not becoming a Supreme Legislature. That's not what the role of a court is in a democracy. The role of the court is to be the interpreter of the Constitution. But it's not to be the ultimate policymaker for the country. So you can't, in interpreting the Constitution, really, if you like, cross the boundary into saying, well, I don't like this law. It's not a great law. And try to use constitutional, if you like, analyses to come to that conclusion. It's very important that we observe that.